and Civil and Criminal Jurisprudence. I think we have the longest name of all the committees. Judiciary and Civil and Criminal Jurisprudence will now, exactly, will now come to order. We're going to start in a subcommittee with Senator Henderson, Senate Bill 235 on Bentley's Law, which this committee heard last year. Senator, you can come up, go ahead and present your testimony. And I know there are several different hearings today, so presenters, if you have to come and go after you present your legislation, that is wholly appropriate. Proceed when ready.
Thank you, Chairman and members of the committee. For the record, Mike Henderson, Senator from the 3rd District. This is a bill that has been around a while. I think we've gotten it out of the House 2 or 3 years, and it's been over in the Senate. It was on a big Judiciary bill last year. Just didn't get to the finish line. We've had it. It's for a lady in my district is where I'm doing it. I think it's passed, and I don't want to misstep or misspeak, but I think it's around 20 states have passed a form of this at this point. She could not be here today, Miss Cecilia Williams, so I'm going to maybe tell her story, then I will tell you about the bill real quick on what prompted this. Miss Williams' son and his wife and their 4-month-old was killed by a drunk driver, struck them, put them into a tree, leaving Bentley and Mason, 2 young children that were left after that, in the aftermath of that. And she kind of started this program, and now, like I said, it's become a nationwide program. Some of the different organizations have become to back it. And what we're trying to do is this. It's basically, it's named Bentley's Law after one of the children. And the idea is if you drive drunk and you take away a parent or guardian of these children, should you have some responsibility for the children that are left? Now, we know first they're going to go after them civilly. So we all know that. They can go after them civilly first, and that's where the money is probably going to be if they have insurance. The trouble is we have so many uninsured drivers in Missouri. Many of them do not have insurance. And we found through research that a lot of them don't have a lot of resources either. But we say, but the idea behind this, they should still have some responsibility. Miss Williams has taken on the grandchildren, and many other grandparents have done the same, or aunts and uncles and so on have taken on these children and make sure that they're taken care of. So what this one does is basically it says that if convicted, individual will be ordered to provide financial support to the deceased children until they turn 18 or 21 if they're in a secondary school. Extended support for incapacitated children. If a child is physically or mentally incapacitated and married, the court may extend the maintenance. Enforcement of payments. And we try to do that through the circuit court. I worked on the payment pieces for 2 or 3 years trying to figure out how we do this. I work with the, some of you may remember Judge Evans, and he kind of helped me with getting some of the people from the courts to get together and say, how can we make this actually work? Because I don't want to just pass a bill that sounds good for them. We were trying to make something that would actually work. And the support for affected children, the bill aims to provide financial stability to these children who've lost a parent or guardian through DWI. So I think we've worked most of it out. I'm not going to go into all those details. I think you've looked at it and you've heard the bill before, but I'd be more than happy to answer any questions.
Thank you, Senator. This seems to be identical to a bill last year, the House Bill 1958, and very similar to 1375, the Senate bill that we heard in this committee. Do you know what any of the changes that were made in the Senate bill?
I don't think there were any changes we made. I think we actually may have worked with Senator Roberts at one time last year on a slight wording change that he wanted. If I remember right, out in with Senator Luetkemeyer at one time, we tried to work on a couple changes, and I think I may have put that wording in here as the only change. I'm going to be honest, I don't remember. It was pretty, I didn't see it as substantial, but he thought it was something that was important to make it work. I don't remember the exact change.
Any questions for the Senator? Seeing none. First witness in support, please come forward. Make sure you have your witness form filled out. You can leave it on the witness stand and proceed when ready.
Good morning. My name is Jared Bright. I'm the Regional Executive Director of Mothers Against Drunk Driving. I've worked with Cecilia, Bentley, and Mason over the last few years. Our victim services team has worked with them and thousands of other individuals across our state who've been impacted by impaired driving. We can't give a number on the number of children that are out there that could have been recipients of this financial support. But what we can do is promise individuals moving forward as a deterrent that if you commit this crime, this is your responsibility post-incarceration. And of course, this allows for a period of time after incarceration for individuals to reestablish themselves and then become supporting of the minors. Cecilia is a wonderful woman, and she doesn't have the financial resources to take care of these kids, but she's worked multiple jobs as a grandma to take care of them because mom, dad, and baby brother were killed in a crash. And it's our responsibility to advocate on her behalf and any future victims and survivors of this crime. We think that this is a great deterrent, and I'll tell you, we have victim impact panels throughout the state of Missouri. The first time that I talked to a group of offenders in a room about Bentley's Law, their eyes lit up because they did not know that this was a possibility if they continued down the path that they were on. And so I truly believe that there were individuals in that room, and it is the purpose of those panels to change behavior directly from victims and survivors, just like Cecilia, Bentley, and Mason. So Mothers Against Drunk Driving supports this both locally and nationally. South Korea has passed it. Canada is passing it. 17 states. It's before now. 7 states have passed it. And here in the region, the heartland is what we call it. In MAD, I'd like Missouri to be the first of Missouri, Kansas, Oklahoma, and Arkansas to pass this and really lead the way in preventing future crime.
Senator Coleman.
I'm sorry, there's 20 states that have passed it, or there's 7 states?
There are 7 states that have passed it,
Okay.
but it is before 17 states.
I understand. And have you seen a decrease in the number of children who have been affected by this crime in those 7 states?
Unfortunately, NHTSA's data is always two years behind, so we don't have the data to show that yet. But what we do know is that the age range of victims and survivors of crashes are between under the age of 29. 0 to 29 is the highest. And so
when was the first one of these passed?
I'm sorry?
When was the first state to pass this?
2 years ago.
Okay.
2 years ago, and I believe the first state was Idaho.
Okay, thanks so much.
Yes, ma'am.
And you said our 51st state, Canada. They passed this as well.
They're working on it. Cecilia actually went to Parliament to testify on behalf of it as well.
Any further questions? Seeing none, thank you for your testimony today. Next witness in support, please come forward. Seeing none, any witnesses against Senate Bill 235? Seeing none, any for informational purposes? Seeing none, any closing remarks?
No, thank you very much for allowing me to present this bill today. I appreciate it.
That will conclude the public hearing on Senate Bill 235. We're going to go ahead and take roll now. Mr. Secretary, please go ahead and call the roll.
Senators Schroer,
Here.
Gregory 15, Brown 26, Coleman, May, Roberts, Schnelting.
All right, having a quorum, we're going to move to 2 bills at the same time. It's going to be Senate Bill 353 from Senator Trent and Senate Bill 434 from Senator Washington, if they're still here. And just for time's sake, go ahead and present both of these bills at the same time. I think the witnesses in support and against probably want to testify one time on both of these bills and just describe any nuances that you may have. And we do have Senator Washington's sub. This is Senate Bill 353 and Senate Bill 434 on the DWI diversion programs. Senators, proceed when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Curtis Trent, representing Senate District 20. We'll attempt to be brief so we can get to our witnesses. So this is Senate Bill 353, creates a DWI diversion program that allows the prosecuting attorney to divert a case to a DWI diversion program if the defendant meets the following criteria. They have not been previously convicted of an intoxicated related traffic offense. They're not currently enrolled in a diversion program. They do not have a commercial driver's license. They did not incur the offense, or they did not commit the offense while they were operating a commercial vehicle. There was no injury or death of another person, and they did not refuse a breathalyzer test. As part of the program requirements, prosecutor or circuit attorney may require the installation of a ignition interlock device. Any person required to install such a device may be shall still be subject to penalties provided under current law, and the court may require the defendant to pay all or part of the costs unless there's indigency on the part of the defendant. After the completion of the program, if the defendant has complied with all the imposed terms and conditions, then the court can dismiss the case against the defendant, record the dismissal, and of course, this would not prohibit or prevent the use of any other diversion programs or other programs that might be available to a prosecutor to utilize. With that, I'd be happy to turn it over to my colleague here, and of course, be happy to answer any questions.
Thank you. I'm Senator Barbara Washington, 9th District, Jackson County. Some of them, I'll just kind of talk about the main differences. They're both for DWI diversion. Senate Bill 434 has the judge that would divert the case as opposed to the prosecuting attorney. The court would determine the conditions as opposed to the prosecuting attorney. The court would also require an ignition interlock for 1 year. There are no additional program requirements like there are in 353. We have not addressed the license suspension during it, but we want to make sure that the suspension, that they're still allowed to drive while they're in the diversion program. And the court determines if the criminal proceedings should be reinstated. So basically, 434 gives the judges more authority. 353 gives the prosecuting attorneys more authority. 353 has some stricter eligibility requirements, which those who refuse the breathalyzer would not be eligible for this. In 434, anyone getting a first-time DUI would be allowed to do that. And then also, the other difference between 434 and 353, if you look at the sub, is that we added a Survivors Act. We added a Missouri Survivors Act, which basically will allow the courts to consider documented abuse as a mitigating factor when they're sentencing folks. So if you've been a victim, say, of domestic violence and you react to that against your abuser, then that's something that the courts would be able to consider when they're sentencing. And I'm going to turn it back over to my colleague because I have another committee. You have a quick question for me?
Senator Gregory first.
Yeah, real quick, Senator. I'm assuming you're wanting to shift it to the courts to make it automatic as opposed to discretionary from the prosecutor. Is that why you want it under the courts?
Yes. And I don't think the prosecutor should be determining. The prosecutor already, their job is to create crime. I mean, is to charge crimes, but they should not be they should not be the persons that's also controls how that person is punished. That's just not how our system is currently set up. And I think that that type of discretion with the prosecutor may lead to unfair application. For instance, someone with a public defender may be treated differently than someone that with a paid attorney, or someone whose attorney is more well known, where the judges, in my experience, have been a little bit more fair to treat all defendants the same way.
So under your bill, I haven't studied it yet, but under your bill, is it automatic if you meet these criteria, you get a diversion program, or does the judge have discretion?
The judge has the discretion.
Judge has discretion. Thank you.
Senator Coleman.
I had a quick question about your domestic violence piece of that. Is that only under this chapter you're asking for that to be taken, or is that new piece broad?
We can talk about that, Senator. We can stretch that out if we need to, but right now it's
I have
just
no
this
opinion
chapter.
about stretching it out or keeping it narrow. I just couldn't find it in the sub, and I'm kind of having a paper chase moment.
Yeah, it's in this chapter right now.
Okay, thanks so much, Senator.
Senator Gregory.
For Senator Trent. So under yours, Senator, it just says no no prior conviction. So that could probably, in a practice standpoint, it's probably up to like a second DWI. The prosecutor could implement a diversion program, right?
Okay.
Yeah, so no prior conviction, but it also means it also includes no previous diversion. So presumably if they'd had a prior DWI incident, it's
And
unlikely
received
that there was
diversion.
no
Gotcha.
interaction with the courts at all.
Perfect, thank you.
Any further questions? Senator Coleman.
I had some people visit me yesterday about your bill, Senator, and had a question on page 3, line 56. In prior draftings, it had a shall require installation of ignition interlock, and the version that I have in front of me is a may.
Yes, that's correct. I believe the intent is to go back to a shall there, because if you have decided to engage in the diversionary program, then it doesn't really make any sense not to have the interlock device.
Yeah.
Like if you, if you don't want to have the interlock device, then don't use this diversion program. Use another
Right,
tool.
pick something else.
Yes.
And then did you have any opinion between your version and Senator Washington has the changes that she outlined between the two of you? Have you worked together on where you'd like to see both bills go, or are you?
I think that's still an ongoing discussion. I always prefer my bill, but I'm happy to work with others to try to find something everyone can live with.
I also like my own ideas best. Thank you, Senator.
Any further
Thank you.
questions? Seeing none. First witness in support of either of these bills, please come forward. Make sure you have your witness form ready, and you can leave that on the witness stand and proceed when ready.
I'd like to express our strong support for Senate Bill 353, the proposed diversion bill. Sadly, I represent thousands of Missouri victims and survivors who've been impacted by drunk and drug driving. This legislation represents a critical step forward in our ongoing efforts to reduce the devastating impacts of impaired driving in Missouri. In my lifetime of living here in Missouri, the number of DWI arrests equals more than the entire population of St. Louis and Springfield combined, and nearly the entire population of the city of Kansas City. When we talk about fatalities, I'll put it into a relevant issue. In the last 42 years, in my lifetime, the number of citizens killed by an impaired driver is the same as 24 747s, crashing and killing all 650 passengers on board. Can you imagine what the response would be from our news media, from our emergency response, from the world, if every other year for the past 40 years, a fully booked 747 crashed and killed everyone on board here in Missouri? 353 seeks to implement a diversion program for first-time offenders, emphasizing rehabilitation and education. This approach aligns with MAD's mission to prevent future tragedies by addressing the root cause of impaired driving and promoting long-term behavioral change. Looking at the next 5 years, it's imperative that we start with first-time offenders, who make up approximately 15,664 on average of the 23,733 DWI arrests each year in Missouri. Of those 15,000, the majority are between 21 and 39 years old. Ignition interlocks alone can prevent approximately 10,000 of those first-time offenders from reoffending. But more than 5,000 will go to pose a clear and present danger to every motorist on Missouri's roadways. Our job must be to partner with private and public partners to do better, to offer more and aim for zero recidivists while simultaneously aiming for zero fatalities. This bill provides a clear and consistent pathway for first-time offenders, and it leaves discretion for the prosecutors and provides our neighbors, coworkers, and family members who have been victimized a way to play a direct role in prevention of recidivism while never forgetting their loved ones. The inclusion of the educational component can only serve to increase the success of reducing recidivism. Studies show that when combined technology countermeasures like the ignition interlock and victim impact panels together further decrease recidivism. Evidence-based programs that address the underlying issues of substance abuse can lead to meaningful change, reducing the likelihood of repeat offenders and enhancing public safety. This not only holds offenders accountable for their actions, but also provides them with the tools and resources needed to make better choices in the future. By reducing the incidence of impaired driving, we can prevent tragic loss of life and the emotional and financial burdens that victims and their families endure. This bill represents a proactive approach to safeguarding our communities and ensuring that fewer families experience the heartache, tragedy, and loss associated with drunk driving crashes. Implementing this diversion program can further alleviate the burden on the judicial system, allowing resources to be allocated more effectively. This ensures that our courts can focus on more severe cases while still addressing the issue of impaired driving. It's a balanced approach that prioritizes prevention, accountability, and rehabilitation. By supporting this bill, we take the opportunity to make a significant impact in the safety and well-being of our communities. I appreciate your time and would be happy to answer any questions you might have.
Thank you for your testimony. Any questions for the witness? Seeing none. Next witness in support, please come forward.
Good morning. I am here to testify specifically on the committee sub, the Survivors Justice Act portion of the bill. And
if you could just introduce yourself for the record.
Yes. Thank you so much for having me. My name is Felicity Rose. I'm the Vice President of Criminal Justice Policy and Research at Forward.us, a bipartisan national political organization that works to help states look at common sense criminal justice reforms that protect public safety, promote fairness and accountability, and prioritize good use of public resources. I am here to testify in support of the Survivors Justice Act. I'd like to begin by addressing the very real crisis of domestic violence in the state of Missouri and how it relates to female incarceration. Nationally, 70% of incarcerated women report experiencing intimate partner violence in their lives, and we know here in Missouri that 50% of women across the state experience intimate partner violence at some point in their lives. Missouri has one of the highest rates of domestic violence in the country, in the top 5, and this is a serious problem that Missouri has tried to address in the past, the way that sometimes these actions become criminalized and end up with women serving time in prison. But the last time this was seriously looked at in Missouri law was in the 1990s, and we know a lot more now about how this actually works in people's lives and the kinds of evidence that they can provide and how to fairly address this issue. So we do know that a lot of survivors are criminalized for their actions because of self-defense, and we have at least one person who's going to testify and tell you all some real stories of Missourians who this has happened to, and why we think it's so important to address this here in the state. But I wanted to kind of outline, why the current law is not working the way it should and what this law would do briefly. So this law has 3 key components. So it creates a mitigating factor in sentencing in cases where domestic violence was a substantial contributing factor to the crime. So that allows judges to consider evidence that right now would not necessarily be admissible and decide if that mitigating factor is appropriate, and then reduce the sentence appropriately. So this is totally at the discretion of judges. It does not mean that people don't get punished at all. It's not. It includes accountability, but it's saying the sentence should take into account all of the circumstances of the case. It also creates an opportunity for judges to review and reduce sentences of domestic violence survivors who are currently serving prison time. So it's been a long time, as I said, since the law was updated on this issue, and that leaves potentially hundreds of women in prison serving sentences that wouldn't be handed down under this law if you all decide that this mitigation is appropriate moving forward. And so this includes a way to go back and address those cases. When Missouri last changed the law around this issue, in the 90s, the legislature created a similar process for people who had been sentenced before that change. That process at the time went through the parole board. We think it's more appropriate to do this through the courts so the judge can review evidence at a higher standard and make the decision about what the appropriate sentence is, as opposed to the parole board, which can kind of just make a decision about in or out. So this would be a little bit more comprehensive review, but it kind of follows on what legislators here in Missouri have done before. And this creates a robust legal process for that review. So it requires a judge review the application, hold a court hearing to examine evidence and question witnesses, and then make the determination using clear and convincing evidence, which is a high standard of proof. A few things this bill does not do. It doesn't guarantee release. Judges retain full discretion in reviewing documented evidence. It does not excuse criminal actions. It allows the courts to impose fair and proportional sentences based on the facts of the case. And it doesn't jeopardize public safety. The survivors who would be eligible under this bill are not a risk to public safety. These are, in a lot of cases, women with children who, committed a horrible act in self-defense to try and save their lives or the lives of their children. And we would really urge the committee to allow these women to bring their cases up before a judge and take another look and see if them sending their lives in prison is really the appropriate sentence for those cases. So we work across we work across the country, and so we've seen this kind of bill work in other states. This particular language is based on a bill that was adopted in Oklahoma last year. And we're happy to say that the first survivor to be considered under that Oklahoma bill has now been released after serving 34 years in prison. And I have written testimony that has a little bit more information about that case that I'll hand out to you all. And happy to take any questions, but we'll also have some folks from Missouri to talk about those sort of specific examples of how this works in Missouri. So,
any questions for the witness? Seeing none. Next witness in support, please come forward.
Good morning, Mr. Chair, members of the committee. I'm Angela Nelson, and I'm the Vice President of Public and Government Affairs for AAA Missouri, and I'm here to talk about Senate Bill 353 and 434. There's been a lack of attention to traffic safety measures across the country over the last decade, and what we're seeing are some very fatal and significant consequences. Even here in Missouri, we've seen our traffic fatalities start to increase again after decades of dropping down. And it does bring the question, why are we continuing to see increases in traffic fatalities when our roads are probably the safest they've ever been in terms of design, and obviously the cars we're driving have more safety features than we've ever seen. And that's really because no amount of automotive or roadway design can overcome deadly driving habits. So we appreciate Senator Trent and Senator Washington for raising awareness about DWI by sponsoring these bills. AAA has historically opposed diversion programs, which in our view weaken enforcement mechanisms. However, as these bills stand, AAA Missouri views House Bill 353 very positively, as we believe it will improve the current state of DUI enforcement in Missouri. AAA is a strong proponent of ignition interlock devices because we recognize the tremendous success of IIDs in combating impaired driving recidivism. In other words, we know IIDs reduce recidivism. But there's more. A recent study by the American Journal of Preventive Medicine actually assessed the deterrent effects of IIDs. The study found that a mandatory IID penalty of 1 year has the same deterrent effect of increasing police enforcement, of adding a mandatory jail sentence of 10 days, or by increasing the fine by $2,000. And that study found that the effect was still significant regardless of the level of alcohol dependence of the offender, their prior DUI experience, or other demographic or psychological characteristics. These bills rely on the mandatory use of IIDs and in an optional but very structured and supervised diversion program. And AAA strongly supports the eligibility provision in these bills that will not allow a defendant to participate in the diversion program if they have caused a crash that has injured or killed another person. AAA would, however, oppose these bills if two provisions are weakened or removed. Those provisions relate to the transmission and maintenance of criminal or conviction records and the treatment of persistent offenders. It is essential that all records of DUI violations remain accessible to courts and law enforcement so that persistent and repeat offenders are identified and handled appropriately. So I thank you for the opportunity to share our observations on behalf of AAA and our 900,000 Missouri members. And I'd be happy to take any questions.
Thank you very much for your testimony. Senator Coleman.
I have a quick question for you. You said in your testimony that AAA supports mandatory, and both of these bills are one more tool that the judiciary would have in their toolbox. You still support them despite them not being mandatory programs?
Well, I think we have the discussion of the shall versus may, but our understanding is that they would be mandatory, and that's where our support would stick.
Okay, thanks so much.
You're welcome. Thank you.
Any further questions? Seeing none.
Thank you.
Moving to the next several witnesses, we're going to move to 2 minutes because we have several other bills and a strict time limit. So 2 minutes, hopefully that's enough. If you have written testimony as well, you can leave that and we'll distribute to the committee. So begin when ready.
Thank you. Good morning, Mr. Chairman, Vice Chairman, and committee members. My name is Deborah Coffey. I'm here on behalf of SAFE, which is Safety and Advocacy for Empowerment. We're representing the ignition interlock industry in support of Senate Bill 353. There are currently six certified manufacturers here in Missouri. That represents 353 service centers throughout Missouri. The average cost of interlock is about $3 a day. Oversight for the ignition interlock industry is provided by the Department of Revenue. The customer gets to choose what vendor they want to use off the website that's provided by the Department of Revenue, and there's a lot of information about how the program works on the DOR website. Interlocks are a proven and an effective tool for behavior change and accountability. 3 decades of research on the effectiveness, and appreciate your support of this legislation, and I'm happy to answer any questions.
Any questions? Seeing none. It was concise.
Thank you.
Oh, one question. Senator Brown.
Yes, sir. Hi, Senator.
Hey, you said on average it's about $3 a day. How can you describe how that's broken down? In the past, I've had a constituent come to me with concerns that I guess you pay a certain amount of price, and then there's required some kind of calibration or something that's required after a period of time.
Yeah, thank you for that question. So there's a one-time install fee, and that varies depending on the type of car that is brought in. If it's a Tesla or a Rolls-Royce, it's going to be a higher install fee. And then there is a monthly charge. The devices are leased. They're not owned by the offender or the customer. And there is a monthly lease, and it breaks down to about $3 a day. There is, depending on the manufacturer, and it's just like you go to the grocery store and you get to choose your green beans. The customer does get to choose which manufacturer they want to go to, and there's just competitive pricing. So some charge for different services, but on average the monthly fee is $3 a day. But you'll note in the bill that there is an affordability program. We brought that forth from the industry. The industry does make up the difference, and we believe it's important that there be some level of affordability plan in the interlock program, and Missouri has lacked that.
So you said there is an affordability program currently?
In the bill.
Oh, in this bill.
Missouri
okay.
does not have one, and 33 other states do, and we thought it was important that Missouri finally have an affordability program for the interlock program.
Okay, and how do you become a vendor of these?
We have to apply through with the DOR. There is I believe, in my opinion, Missouri sets the standard for that certification process. It's pretty rigorous, and that we have to fill out applications. Our devices have to meet NHTSA standards. They have to exceed them according to the Department of Revenue specifications. We have to provide devices for them to specifically test, put in their own vehicles and test. They go through rigorous testing and meet those certification requirements. And I'm happy to share with you a copy of the DOR Administrative Rules and Regulations if you'd like to see what those requirements are.
Yeah, that'd be fantastic. I'd love to have a conversation with you offline sometime, because, like I said, I've just heard concerns from people that have gone through the program, and everything from the cost, just inability to communicate, calls not being returned, things like that, and yeah, any opportunity to expand my knowledge on the program, I'd appreciate.
I'd love to address those with you. Thank you, Senator.
You bet.
Any further questions? Seeing none. Moving to the next, witness and support. Please come forward, have your witness form ready and filled out, and proceed with your 2 minutes.
Good morning. My name is Ellen Floatman. I'm an appellate attorney in the public defender system. I am testifying today in my personal capacity. My views do not represent those of the public defender system necessarily. But I'm going to talk about the Missouri Survivors Justice Act part of SB 434. Because I want to talk about one of my clients that I represented back in the 90s. I'm going to call her Jane. She was convicted of first-degree murder for killing her sexually abusive father, who had been raping her from the age of 8. She shot him when she was 18, and she was convicted of first-degree murder. The jury felt they didn't have a choice but to convict her because, like many victims of abuse, she killed her father at a time when she was not at that moment in danger, so her crime did not meet the elements of self-defense. But the jury felt they didn't have a choice but to convict her of first-degree murder. The trial judge has to report to the Missouri Supreme Court when they have a first-degree murder case, and in this case, the trial judge's report said that the sentence was surprising and a conventional life sentence would be more appropriate. That was in the trial judge's report. The jurors, after sentencing, signed affidavits saying they felt the sentence was too harsh, but they didn't have any alternatives under the law. One of the lead investigators with the major case squad who investigated Jane's case also signed an affidavit saying the same thing, that he believed she had been sexually abused and that was the reason for her crime. But she had a first-degree murder conviction with a life without possibility of parole sentence. It took 16 years, 4 governors, and she was finally released on a clemency petition. She would not have qualified under the 1991 provision because her crime was committed in 1990. Commutation or pardon were her only options at that point. You all have an option. You can pass a bill that gives judges discretion in a case like this to who are convinced that a criminal defendant is a survivor of domestic abuse, to give a sentence that's within a more appropriate range of punishment under the circumstances.
Your time has expired. If you could just wrap up your
Thank you.
your thoughts.
If there are any questions, I'd be glad to entertain them.
I appreciate that. Any questions? Seeing none.
Thank you.
Next witness in support, please come forward.
Hello, good morning, Chairman, members of the committee. My name is Gwen Smith. I am a criminal justice policy manager with Empower Missouri and here to testify in support of Senate Bills 353 and 434. Today, I just want to echo what has already been said, as well as adding a few points about the efficacy of diversion programs. A 2021 study that based on Texas diversion programs found that defendants that did not have a prior felony conviction that participated in diversion had an immediate dramatic reduction in subsequent offending to the tune that the total number of future convictions fell by 75% over a 10-year follow-up period compared to similar defendants that did not have that diversion. Similarly, there's research that showed that every dollar invested in drug treatment saves $12 through the reduction of future crime and healthcare expenses. In 2019, arrest data showed for over 14,000 individuals in Missouri arrested on suspicion of drunk driving. So I think that these DWI diversion programs are well-timed and would make a really big difference in our state. We also want to echo support for the Missouri Survivors Justice Act language that's been added in the committee substitute. We think that this is a really smart sentencing approach that takes important context into consideration. Thank you for your time.
Thank you. Any questions for the witness? Seeing none. Next witness in support, please come forward.
Mr. Chairman, members of the committee, Alex Eaton testifying on behalf of FAM today. I was not aware that the survivor justice language was going to be put in the committee sub, so that's the only piece that I am going to testify in support of, but happy to take any questions. Appreciate both senators bringing that forward, and I will fill out a witness form and bring it when I come back, so appreciate it.
Any questions? Seeing none.
Thank you.
Next witness in support? Seeing none. Moving to the witnesses against. The first two witnesses will have a 5-minute time limit, just to be concise, and then moving to 2 minutes for all witnesses thereafter.
Thank you, Mr. Chairman. My name is Darrell Moore. I'm the Executive Director for the Missouri Association of Prosecuting Attorneys and the Missouri Office of Prosecution Services. We originally weren't going to testify today because we really have no heartache over any of these bills, but I am here to testify against Senate Bill 434. And to keep it short and within hopefully 2 minutes, Mr. Chairman, I will just say of the interlock ignition devices, the DWI programs, we support Senate Bill 353. I didn't intend to say that. I'll modify my bill, but we worked with the sponsor last year, and it's not just because Senator Trent's one of my senators, but we worked thoroughly on it last year. It's the same bill. It has more stringent requirements. We disagree with 434 because prosecutors do and should have the discretion, and not a judge. The prosecutors are the ones who initially get the case. We run all the diversion programs. As some of the committee may remember, in 2019, we asked this by the General Assembly to pass a bill specifically authorizing prosecutors to do diversion programs. And we had to do that because some judges in the state didn't think we had the authority, which was shocking to me because as Greene County prosecutor in the 2000s, I was running diversion programs all over the place. But we did have some judges in places that thought we didn't. Finally, in terms of the Survivors Act, there's a problem with it. It is poorly written. Having argued cases in the Missouri Supreme Court and the appellate courts of the state, if you look at page 6, if their intent is that this only applies against victims of crimes that committed domestic assault against them, then it needs to clearly say that through the whole bill. Instead, if you go to page 6 and the bottom of page 5, the way it reads is it says that in 565 offenses, the murders and the assaults, that if the victim of those offenses were the abusers, then this can be used against them. But nowhere else in the bill does it say that. And so you could say, well, only for 565 offenses would it apply to the victim that committed the assault. So can a person that was a victim of domestic assault under this version go out and commit a burglary and then use a domestic assault history against a victim that had nothing to do with them? So just pointing out, it's poorly worded if you read it. We just became aware of this last night. And then secondly, we would argue two other things. One, the best place to handle this, as I think Senator Roberts, as I recall, was a prosecutor at one point, the best place to handle this is during the trial. And more importantly, if you really want to emphasize this, the sentence assessment reports should look into this. This is where it should be required. If there's going to be any rewriting, there should be a requirement that probation and parole specifically look at the issue in the sentencing assessment report that is relied upon by the court and the prosecutor and the defense attorney. And then furthermore, I would tell you, in my 40-some-odd years' experience as a prosecutor, the public defenders and most private defense attorneys already prepare a sentencing memorandum anyway to give to the judge, and they already highlight these things. So we would argue that you don't need the statutory change unless you want to say that probation or parole specifically needs to be instructed to look at the issue as they prepare their sentencing assessment report. And then finally, we certainly oppose any retroactivity. I mean, this bill would require opening up all people being sentenced. That runs contrary to the other bills that this committee's going to hear this morning. What we're being in search of, and what the governor's in search of, is that we have some certainty in sentencing. This undoes that whole thing. It would be contrary to the intent of those other bills. We're not here to testify on those other bills. We do agree with the concept there needs to be a determinate sentencing structure. And then I will also conclude by saying, I told one of my other senators, Senator Moon, I wasn't here to testify, but his bill on lifetime protection orders, we like, for what that's worth. So I'll be glad to take any questions.
Any questions? Seeing none. Moving to the next witness in opposition.
Good morning, Mr. Chairman, members of the committee. Brian Bernskitter here on behalf of the Missouri Association of Criminal Defense Lawyers in opposition to Senate Bill 353 and 434, although we're just learning about the Missouri Survivor Justice Act, so we do, that does sound like a bill that we would support. I just want to bring up a few issues. Certainly we're not trying to make, we understand the issues with impaired driving, and we're not trying to make light of any of those issues, but we do have some technical issues and problems with the bill. First off, statutes already allow prosecution to do a tremendous amount of diversion in any way they see fit. Section 557014 currently allows prosecutors to divert criminal cases in any number of ways that work for the prosecution, the defense, and the person involved. We feel like standardized or putting this in form. I know previous witness mentioned the fact that they had issues with whether or not they could do this. I think the statute's pretty clear that they have a wide array of discretion when it comes to this. Another issue that we want to bring up, the bill seems to say that you don't have a requirement for a finding of guilt or a pleading of guilt, and yet the crime or the participation in the diversion program would be used against you. We think that's probably an unconstitutional provision and certainly poses some issues for the bill. Please.
Brian, is that in both versions or just in one?
I think it's in both. I have not seen a sub for the, I know it's in 434. It's in, I think it's 12. Where am I at here? Oh, that's 434. Where's 353? It is in 353 on sub 12. For the limited purpose of determining a defendant is chronic, the criminal case is diverted and successfully completed shall be counted as an intoxicated and related traffic offense. That's in. I didn't find it in 434, but in a quick review, but it is in 353.
And remind me, which client are you testifying on behalf of?
Missouri Association of Criminal Defense Lawyers.
Okay, thanks so much.
And then the other issue, these devices, Senator Brown alluded to the fact that these devices pose a lot of problems for constituents. Anecdotally, we find a lot of folks that engage with these devices have problems with them. One thing that I do want to point out, just as something that's not been considered, these devices do require running retests. That's a tremendous opportunity for distraction. While you're driving, you're required to pick these devices up, engage with them, and then put them back down. We do think that's, obviously probably an unforeseen issue with, creating further distractions on the road. We have some other issues with the bill, but for the sake of time, we'll go open ourselves up for questions.
Any questions? Seeing none.
Thank you.
Moving to the next witness in opposition. Seeing none. Any for informational purposes? Seeing none. Senators, do you have any closing remarks? All right, that'll conclude the public hearings on Senate Bills 434 and 353. We're going to move to Senator Moon on the, let's do Senate Bill 197 first.
Good morning, Mr. Chairman and committee. Thank you for your indulgence this morning. I have several things going down in the hearing room in the base or in the first floor, and after I present these bills, I'd like to excuse myself and go back. I'm Mike Moon. I represent the Missouri 29th Senatorial District. And essentially, and the basics of Senate Bill 197 is it will allow lifetime protection orders to be issued at the time of sentencing, as opposed to having to come back and potentially face your perpetrator multiple times. I have two witnesses who wanted to be here but unfortunately could not be, so I have testimony in print that I'd like to distribute to the committee. I want to overview one particularly because Kaylee Kozak was here last year to present testimony in favor of the lifetime protection orders. She's a survivor of childhood sexual abuse. As a result of that, in her adulthood, she proposed and supported what is now a namesake, Kaylee's Law. When she was 12, she was sexually abused by her middle school teacher and soccer coach. And you can only imagine how devastating that would be. And she had to return to court multiple times, face him, and then ultimately get lifetime protection orders against this individual. I will forward this to the committee later today, if you'll allow me to. And Lisa Saylor is another who has submitted a testimony as well that I'll print that for the committee. But it's really, I think, that's the basic overview. And I think it's understandable that we should be advocating for these victims to allow them to get lifetime protection orders at the time of sentencing. Any questions?
Now, this is the same language that we saw last year in Senate Bill 869?
Yes, it is.
Okay. Any questions? Seeing none. First witness in support of Senate Bill 197, please come forward.
Mr. Chairman, Darrell Moore again. I just reaffirm what I said in the other bill. We strongly support this bill. Again, didn't intend to come testify, but we had no problem with the bill. And since I was here, we support the bill and what it would do for victims. Thank you.
Thank you, Mr. Moore. Any questions? Seeing none. Next witness in support. Seeing none. Any in opposition? Seeing none. Any for informational purposes? Seeing none. That will conclude the public hearing on Senate Bill 197. Now, for the next three bills, it's going to get a little wonky. I believe Senator Trent is going to testify for Senator Trent and Senator Carter, from what I've been told. I believe that's correct. So, Senator Trent, you can join Senator Moon. And I know there are some nuances and differences in these three different versions relating to minimum prison terms. And for the sake of time, we have about 45 minutes left. We're going to go ahead and present the public hearing on Senate Bills 281 with Senator Trent in for Senator Carter, Senate Bill 251 for Senator Moon, and Senator 449 for Senator Trent. Seniority, you can pick whoever wants to go first.
Senator Trent has deferred to me going first, and I'm grateful to him for that. Thank you very much, Senator. 251, I'm going to be very brief here. I've been in conversation with sheriffs, at least in Southwest Missouri primarily, but across the state sparingly, who want to see some truth in sentencing. And so I've had conversations with the director now, the new director, and he has some ideas that I think are worth consideration. So I'm going to defer to him. He may be called up. I hope he will be to give his insights. And I think that we need to get all sides together, if appropriate, and I think it might be, to talk about what should be considered. And I'm grateful that he is wanting to be a part of the conversation. I know some sheriffs perhaps are here to testify in support as well. So if there are questions, I'd be happy to take them, but I think they'd be better answered by those in the audience.
Thank you, Mr. Chairman, members of the committee. Curtis Trent, representing Senate District 20. The first bill I'll talk about, Senate Bill 449 first. That is very simply structured. You'd be required to serve 80% of the covered offenses under the Act. There are no changes based on number of commitments or anything like that. And like the whole point of this is to create a degree of transparency. I mean, we're not necessarily trying to lengthen prison sentences here, but we're trying to have transparency so that both victims and defendants and everyone involved in the process knows exactly how long someone's going to serve when they are convicted and a sentence is imposed. With the underlying goal being the enhancement of public confidence in the criminal justice system, in the deterrent effect of the sentences that are imposed by court, and all the attendant good that comes from that. 80%, I think, is a number that's subject to negotiation, but 80% was chosen because that preserves, some of the good behavior incentives that you want to preserve in the system. Now, Senate Bill 281 it differs insofar as it still contains some of the previous commitment formula. So I believe the first offense, you serve 75% of your sentence, and then if you have a previous prison commitment, then it goes up to 80%, with some deviation for certain types of crimes. Armed criminal action, for example, I believe you're required to serve 100% of that sentence, and there's some other offenses in there as well where 100% is imposed. With that, I'd be happy to answer any questions on these bills.
I've had conversations with Senator Moon, Senator Carter. Are you opposed to working together and crafting one piece of legislation on this rather than having several different approaches?
No, I think that's preferable if we have one unified approach. I think that the underlying goals here, I think, are fairly uniform between the various different bills, and I think in a lot of the various different groups that have an interest in this, and particularly the sheriffs, we want to accomplish the same thing, and so the fine details, I think, can be adjusted to try to serve all those aims.
Any questions? Seeing none. First witness in support of Senate Bills 281, 251, or 449. On these bills, please make sure that you have your witness form filled out and noted which bills you're testifying for or against, and yes, you can testify for all of the above.
Hello, I'm Jay Schroeder, President of Missouri Fraternal Order of Police, and I'm here to testify in support. Just to give a little background how this affected me, about 7 years ago, my house was burglarized. Caught the burglar. He got 5 years and a sentence. He was out in probably 6 months. While he was out, he committed another burglary. Well, this is a burglary first, where he went into a house and attacked a lady. Went back for a little bit, got out. So within a 5-year span, when he was supposed to be in for at least 5 years, he then went down to southeast Missouri area, stole a car, stole a gun, and then got in a chase with the police, and now he's back in prison. So I think we need something like this just to make sure that kind of thing doesn't happen.
And Jay, for the record, are you on all of these bills?
Yes, sir.
Okay, perfect. Any questions? Seeing none. I think for the sake of argument, how many are against these bills? And how many for? Okay, let's just go ahead and alternate. Would the first witness in opposition please come forward? Absolutely.
Good morning, Chairman, members of the committee. Again, my name is Gwen Smith, Criminal Justice Policy Manager with Empower Missouri, and here to testify against Senate Bills 251, 281, and Senate Bill 449. We believe that these bills move Missouri dangerously backwards by significantly increasing the sentences that individuals would be mandated to serve prior to being eligible for parole. A couple things that I want to note, rhetoric around crime and perceptions around crime, might make folks feel that the threat of public safety in Missouri has been getting worse, but the data does stand counter to that. Recidivism data over the last 10 years shows that from 2015 to now, we have had a 32% decrease in recidivism for violent crimes, and similar decreases across the board for other types of offenses. When we think about the theory of crime deterrence and what actually deters crime, there's strong evidence that shows that increasing prison sentences does not actually deter crime. Would-be criminals are unlikely to look up state statute, see that it's increased, and then take that into consideration when thinking about whether or not to commit a crime. One thing that certainly does decrease the likelihood of crime is the certainty of punishment, the follow-through with which law enforcement is able to clear those crimes. And so Senator Schroer, I believe, has a bill that has been proposed, Senate Bill 473, that proposes a reporting system for improving violent crime clearance rates. We believe that these types of strategies are a much better public safety measure for Missouri at this time than increasing mandatory sentences to make a true difference in the root causes of violent crimes. In 2022, 64% of violent crimes reported to police in Missouri were not solved. And so if we're concerned about getting at the root cause of violent crime, the majority of violent criminals are not being caught at all. And so these mandatory increases would not have any kind of impact on them. States that have doubled down on truth in sentencing provisions in recent years have seen very negative results. In Wisconsin, there was a 14% growth in prison population and a severe programming shortage as a result of passing similar legislation. Georgia has seen dangerous environments within prisons, which has led to more crime committed upon reentry and significantly higher reincarceration rates. When we're seeing drops in recidivism rates in Missouri, I don't think we want to do anything that would move the needle backwards on that. In Arizona, when passing similar legislation, they saw a subsequent 50% increase in rules infractions in prisons and a 20% reduction in educational programming enrollment and a higher rate of incarceration. And a lot of these, the increased rules infractions, decreased programming enrollment is because early release is one of the best tools that prison staff, correctional officers, and case managers have at their disposal to encourage good behavior while someone is locked up. The ability for folks to get an early release, to earn time off, is a very strong incentive to both participate in an educational program and to toe the line in terms of avoiding rules infractions while incarcerated. So by removing that tool and increasing mandatory percentages served, we would be making our prisons less safe at a time when prison deaths are already at a record high and DOC is already having a very hard time attracting and retaining staff. Director Trevor Foley recently stated in Senate Appropriations Committee that the DOC currently has 960 staff vacancies, and as a result, last year Missouri spent $54 million on overtime pay for COs. I don't know if these fiscal notes take that overtime pay into consideration, but that is a very significant cost that will only increase as more staff are needed and staff vacancies continue. We believe that increasing minimum sentences will increase both the prison population and correction cost without having the added benefit of making our state safer. Prisons now cost states about 5 times what they did in the mid-1980s when a lot of our sentencing policies were first instated due to having to house and feed people for much longer periods of time. The fiscal notes for these bills note that if the bills were passed, the Department of Corrections would almost certainly need to build a new prison facility. The cost of that new facility is not included in the fiscal notes, but DOC has projected that that could cost to the tune of between $800 million and $1 billion at a time when we're considering cutting costs and cutting taxes in Missouri. I think that the threat to taxpayers that these bills would incur expense-wise is just too great.
While your time has expired,
yes,
a couple seconds to wrap everything together.
Thank you so much. I do have a couple documents that I'm going to pass out to the members of the committee in addition to leaving my testimony here. A commentary from Rachel Wright from Right on Crime that recently ran in the Missouri Independent about these types of increases to prison sentences and the threats to public safety, and then some separating fact from fiction, just a one-page fact sheet challenging some of the stats here.
If you leave that with your witness form, we'll get to the
Okay,
entire
great, thank
committee.
you.
Any questions? Seeing none. Moving back to witnesses in support, you'll have 5 minutes. Please come forward. And I know the director is here. We plan to discuss for informational purposes once we get there.
Good morning, Mr. Chairman, committee members. My name is Steve Pelton. I'm the sheriff of Franklin County, and I also represent Missouri Sheriffs United and Missouri Sheriffs Association. I think it's important to note that there's 115 sheriffs in the state of Missouri, and it's hard to get all of us type A personalities to agree on anything. But one thing for certain is we can agree on is truth in sentencing. For years, we've been trying to get something accomplished, and we hear this from our victims at the local levels, your constituents also, as well as our constituents, and I'm certain every committee member has talked to their sheriff. But we want to hold, there needs to be a consequence for an action. And our victims deserve transparency, so when they're in a courtroom and somebody's sentenced to a certain amount of time, they should serve that certain amount of time. And I know that you guys are going to discuss the percentages and maybe try and combine the bills. We're not sitting here on a dead set percentage right now, but there needs to be a consequence for an action in order to deter crime. I really think it will deter crime, and it gives accountability. I think that when an offender that turns into a career criminal, I'm not talking about your first or second time offense, but there's sometimes we have criminal histories that are 2 or 3 inches thick that we're trying to decipher through. And that's just the ones that was able to be proof beyond a reasonable doubt. We can't catch every criminal, that is true, but we deal with 10% of the people 90% of the time. And there is offenders in my county that, because all of our counties, I'm 6th generation in my county that I live in, everybody knows everybody. When you got people that know my family's names and know ask how my family's doing when I arrest them versus the good citizens that we don't deal with, because the times we're dealing with them is in crisis because they're a victim of a crime. So I'm going to save some time there for Sheriff Cole. I know he's going to come up and go into further detail with you. We're just asking for some support in regards to this. I'll be happy to answer any questions.
Thank you, Sheriff. Senator Coleman, you answered her question.
Thank you, sir.
All right. Next in opposition, please come forward. You'll have 5 minutes. And then after this round, we're going to move to 2 minutes. Make sure you have your witness form filled out. Leave it on the witness stand and proceed when ready.
Good morning, all. Thank you so much for allowing us this opportunity to speak in opposition for Senate Bills 251, 281, and 449. My name is Michelle Smith. I am founder of an organization called Missouri Justice Coalition, and what I do is I advocate for people who are incarcerated concerning humane living conditions while incarcerated, medical problems in treatment, and a host of other issues, and I also support family members. I am here to testify in opposition of these bills because I understand that incarcerating people is not the solution to our societal problems. We definitely have some issues in our communities. I'm not here to, the sheriff that just spoke, I'm not here to say that he is wrong and these things are not happening. They are, but incarcerating people for longer times are not going to fix that. What people need are actual support. A lot of these issues, especially in rural Missouri, are because of drug addiction. So we actually need community drug addiction treatment, mental health treatment, and social service support. And those things will actually go further than incarcerating people for lengthy periods of time. But I have a couple of points I wanted to make as well, and to follow up with what Ms. Gwen Smith said. Missouri DOC is severely understaffed. There are times where programs and classes are not held because the staffing is so short. So things like educational programs, I don't know if you know, but like Lincoln University, WashU, and other universities have classes in our prisons. Well, if there are not guards that are able to cover, those classes in the areas of those prisons, those classes are not held. Things like going to the library, if there is not a guard able to be put in that area, you can't go to the library. So the staffing issues not only, of course, affect staff safety, but they also affect the programs and activities that people incarcerated actually need. My next point is that longer incarceration times really lead to hopelessness of people who are incarcerated. So there are instances where people who go into prison who have very lengthy sentences act recklessly because they feel like, I have, all these years. I don't have anything to look forward to. I don't qualify for certain programs because when you are incarcerated, things like job training or trade programs or educational classes, you only qualify for those when you have so much time at the end of your sentence. So if you're spending more time incarcerated just in this state of being hopeless and upset, angry, etc., it is definitely going to take a toll on the entire system as well as the people once they are released. So I think that longer incarceration rates are really something that is harmful concerning people's just mental health and also their ability to be rehabilitated. I'm also really concerned about Senate Bill 281's provision about first-time offenders having to serve 75% of their sentence, even nonviolent offenses. This is something that, really flies in the face of all of the work that many people have put into, including people who are elected officials, concerning trying to make sure that, especially a person's first mistake in their life does not lead to a case where, their whole life has been thrown away. And lastly, I will say concerning, I really thinking about like the issues of crime and, the recidivism and how even the sheriff just spoke about, they keep rearresting the same people. And again, like I said, a lot of those issues are because of drug addiction. Prison does not fix drug addiction. Actually, a lot of drugs are in the prisons. Missouri DOC has a lot of overdoses, a lot of overdose deaths. Even the prisons that are supposed to be treatment facilities have a plethora of drugs running through them. So going to prison does not fix drug addiction and actually exacerbates it as well. And currently in our state, that is something that we are trying to advocate around, trying to figure out how to stop the proliferation of drugs in our prisons and how to make sure that people, once they're incarcerated, get the rehabilitative programming. But fixing a drug addiction issue is not something that is going to happen in prison. And so I want to just go ahead and end with that and ask you all to really consider how to fix the issue that our community and our sheriffs are talking about, and understanding that incarcerating people for longer times is not going to fix these issues. We need actually societal solutions to these problems. So
that was exactly 5 minutes, so
okay,
you should be proud of that.
Thank you.
Good testimony. Any questions? Seeing none.
You all have a good day.
Moving back to the support of Senate Bills 281, 251, and 449. And we're moving to 2 minutes for all witnesses until we get to informational purposes. Make sure you have your witness form ready and go ahead and proceed.
Morning, everybody. Thank you for allowing me to speak. My name is Roy Cole. I serve as a sheriff in Webster County, Missouri. In the past, I've been the president of Missouri Sheriff Association. I have a lot of experience in the field. The subject of truth in sentence is kind of an important one to me. I've spent a lot of time and efforts on it. I've worked with a lot of people that you've heard talk here before. There's several different directions I want to go, but I know we have limited time, so I need to just speak to the issues as quick as I can. The people that spoke against these bills, they made a lot of really good points, and I think those things need to be considered. And when we go to a bill that we all agree to, and I think we can, because the principles of the matters we can agree to. I've had this debate a lot. I serve on the task force with the Missouri Supreme Court, whether it be defense attorneys. I've talked with Trevor and Director Foley in the back, prosecutors, sheriff's offices, victim advocates. People need to know what the sentence is going to be, and nobody does. I'm not asking for long sentences. I'm asking for clarity in sentences. Nobody knows what they are. Not the judge, not the prosecutor. No attorney in this state can read 558019, look at the sentence, and understand what's going to happen in the courtroom. People have a right to know. Victims have a right to know. The defendants have a right to know. If you're trying to plead guilty to a crime, if you're given 2 years in the state of Missouri, that may mean 3 months or may mean 18 months. That may mean a new career. That may mean a divorce. There's no telling how it will affect your kids or family, and you don't even know what you're pleading to because we have no clarity, we have no truth in our sentences. So what we are asking for is clarity in sentences. I'm not asking you to get rid of good behavior. I want truth in sentencing, which would be, some type of automatic number that we know what it is, good behavior, and probation parole. Okay, so a three-pronged approach where all three goals are accomplished. I feel we have to do that to have some type of law and order in the state of Missouri. We have lots of laws, but right now it doesn't feel like we have a lot of order. It's a very confusing time in terms of sentences. So I'd take any questions if anybody had any.
Well, I think you kind of illustrated what most of the members on this committee want to do, and that's take into account the issues. I've got a case in front of me that I'm looking at. A man convicted of molesting his daughter and stepdaughter was merely released after 120 days. Sure. And I know Jay from the FOP, he's got many different stories of offenders that were sentenced to years behind bars and were out back on the streets reoffending. And at the same time, I think all the testimony that we've heard in opposition to these bills will be considered in trying to craft something to finally deal with this and provide some transparency and actual truth in sentencing.
Yeah, if I could make one more comment. Yesterday I was Googling truth in sentencing. Most people consider Missouri already a truth in sentencing state. You have predetermined classifications and the sentences are supposed to fall under there, but we have so many loopholes and confusing matters in those statutes that there's more exceptions to the rules than there are actual ability to enforce the rules. So it just really needs to be cleaned up and clarified what's going to happen when the judge makes a decision.
Any further questions? Seeing none, thank you for your testimony. Now moving back to opposition. You'll have 2 minutes. I know you have your witness form, so just leave it up there and proceed when ready.
Mr. Chairman, members of the committee, Alex Eaton testifying this morning on behalf of FAM as well as Action Now Initiative. I think the previous witnesses did a good job. I'll just add, I think everyone in this room agrees. I think transparency needs to be the goal here. I think we're welcome, or we're open to working with all groups to try to find transparency so victims know when sentences happen, what they're being charged. I think our goal is doing that without increasing sentences. And then I would also add, Governor Kehoe on day one in office created executive order, I think 25.07, that's bringing, working with probation and parole, DOC, other groups involved in that to, I think, come up with some structure, some form. So, we believe, let that maybe run its course to see where they land before taking these steps and moving forward. But happy to take any questions. Appreciate the committee listening to these bills this morning, and I'll leave witness forms and everything else here.
Senator Coleman.
Alex, I'm glad you brought up the governor's executive order on his first day in office. One of the things that's so frustrating is that if you are a defendant and you're making a plea deal, you have no idea what you're actually going to get. In fact, I'd like to thank the director. He's going to talk in just a few minutes, but he's sending somebody to my office with the actual binder to determine how long you actually serve. And I think that everybody understands that that's not fair. Victims deserve to know. Defendants deserve to know. The judges right now are sometimes even calling and asking, if I want Alex to serve 24 months, what do I have to do based on his circumstances? All of that, I think everyone agrees, is unacceptable. We need to have clarity in our statutes, and we need to have clarity in sentencing. So I appreciate your willingness to work as we work through these bills and as the governor works through his executive order. I don't think that because the second floor is addressing these concerns means necessarily that the legislature should not also look at them. but I think that that work needs to be done in tandem. So thanks for bringing up that executive order.
Absolutely. Thank you.
Any further questions? Seeing none. Thank you for your testimony. Moving back to testimony in favor of these bills. Do we have any more in favor of these Senate Bills 281, 251, and 449? Seeing none. Next, in opposition, please come forward. You'll have 2 minutes.
Thank you, Senator Shore. Appreciate it. Jeff Stack is my name. I'm with the Mid-Missouri Fellowship of Reconciliation. I'll try not to repeat what other folks have said, but we recognize and understand why crime victims would feel frustrated, and as the Senator mentioned too, about defendants being unsure about sentencing. That is a real concern. I think we have to be mindful, though, that quite frankly, all too often prisons are basically warehouses of misery for a lot of folks, and they become places where people become more able to commit crimes in the future. So I guess, as you folks probably realize, there are already 2 million people in our nation's prisons and jails, way more than any other country in the world. And we have, when we look in terms of the rates of incarceration around the world, Missouri has about 713 people in prison for every 100,000 people in our state. Across the world, you look elsewhere, for instance, in Great Britain, that figure is more about 144 people per $100,000. We suggest that jails and prisons are the way to move forward, and we're not addressing other issues. Poverty, the need for people to get drug and alcohol rehabilitation immediately. When I've worked with people at the shelters in town in Columbia and the soup kitchen, when people need to get into treatment, they need to be able to do it right away. We have these other issues that really aren't addressed, and to try to go ahead and it's called, of course, truth in sentencing, but in reality, it really seems like as it's being presented, it's really harshness in sentencing. What can we do to be tougher? We've seen this over the decades, and we've had this, both Democrats and Republicans, President Clinton, President Reagan, and others. This has been kind of going on for a long time, and we need to not resort to prison as the end-all and do-all for public safety. We need to figure out the more constructive and compassionate solutions. I thank you for your time. I'm glad to
Thank you for your testimony. Any questions? Seeing none. Next, in opposition, please come forward.
Hello. Thank you for having me testify again. My name is Felicity Rose. I'm the Vice President of Criminal Justice Policy and Research at Forward.us, a national bipartisan organization that I already told you all about before, so I won't spend a lot of time. We just wanted to rise in opposition to these bills. I think echoing a lot of the things folks have said, I have worked in a number of states across the country, maybe 10 to 15, everywhere from Arizona, where everyone has to serve 85% of their time, to Utah, which is a completely indeterminate system where the parole board makes all decisions. Someone sentences 1 to 15 years, and the parole board decides where in that they want to let them out. There is not a perfect system or a perfect number that's going to solve every problem. And I think the thing I just wanted to point out is, as the last witness said, certainty and truth does not have to mean longer time spent in prison. When you're talking about moving someone who currently, Missouri actually does have, and I understand in hearing that there's loopholes and there's things that need to be considered, but Missouri does have set minimums for most of the people in prison. People convicted of dangerous crimes have to serve 85% already. So we're not talking here really in these bills about for the most part, about the people who are committing serious violent crimes. We're mostly talking about the non-dangerous crimes, people who are driven by their addiction, property and drug crimes. And the question is, what's going to actually work to make Missouri safer? And in my experience, and the research shows that it's not necessarily adding more time. We're talking about, maybe someone who has a 4-year sentence, that's the max for the lowest level felony in Missouri.
rather significantly, but that has resulted in a much different makeup of our incarcerated population. We have a stronger higher raw numbers and a much higher percentage rates for violent offenses and for sex-based offenses for the individuals that we incarcerate, serving longer terms and serving greater percentages of those sentences. That is really stressing, despite the fact that our prison population has dropped, it is really stressing our current physical infrastructure. 6 of our 19 facilities were not built to be prisons. They were repurposed from other facilities, not really particularly secure and appropriate for to incarcerate a more challenging population. These are just some of the bigger concerns, and most of those come down to resourcing. As you will note from the fiscal note, there is quite a bit of time before the impacts of these bills would hit. So I suppose there is time to address those resource issues, but given the general perspective of the state budget over the next few years, that's probably going to be a challenging thing to do. And then the other thought primarily would be the reducing the parole discretion. Parole is a significant operational benefit for the department. If an individual comes in and knows that they can earn their way to less time in prison, that generally is a powerful motivator. And then also upon release, they get the opportunity for some level of supervision in the community also, which typically does not happen. Most recidivism does not occur within the first 12 to 18 months of release. It occurs 18 to 36 months out from release. So a longer parole time is impactful to be able to get effective supervision. I would also say that, very similar to echo some of the Sheriff's comments, Sheriff Cole's comments, many states are looking more at a transparency in sentencing model that brings the certainty, but also addresses exactly the issue that the sheriff brought up of, at the moment of sentencing in a courtroom, no one really, oftentimes many stakeholders don't know the true impacts of that sentence. And I don't know that some of these concepts really address that issue because, as the sheriff brought up, there's so many exceptions in current sentencing law. It's just a very complicated thing. Senator Coleman referenced the records officer manual. It is literally almost 6 inches thick, and it is designed to generate 3 dates: the parole eligibility date, a conditional release date, and a max sentence date. And it is quite a complicated math problem in many of the cases we get to come up to generate those 3 dates, and those are not known until the individual is already serving their incarceration with corrections. A vast majority of the litigation the department's involved in is related to time served calculations. It is because it is just a extremely complicated area of law, and many other states are starting to focus more on those issues. Texas, North Carolina, other states have started more of a complete sentencing overhaul effort, really aimed at certainty, obviously, but also at the transparency at the moment of sentencing, which is even more impactful when north of 2/3 of all criminal cases are resolved by plea deal, as opposed to jury conviction. So all parties to the negotiation of a plea should probably be informed about the impacts of the result of the plea. And I'm happy to answer any questions.
Thank you, Director. I know you've answered several of my questions. The one related to the executive order, can you just describe how the implementation is going to look for you guys and DOC?
So we are currently gathering the working group that would be, per the executive order, we were to gather a working group of stakeholders within the criminal justice system. We're gathering that group now. We will begin to meet and start working through the issues around the updating. First of all, the parole board CSRs have not been updated since 2017, I believe. Updating them to reflect current practice, obviously, but then also making them more transparent. Really with the intention being that stakeholders in the criminal justice system would see the factors that specifically see the factors and the information that the board is using in order to make its determinations.
Senator Roberts.
Yeah, you touched on it briefly. Any other trends that you're seeing in other states that we should be aware of?
It's obviously a very mixed bag with
Sure.
all the laboratories of democracy. You have a number of states that in the decade, as previous witnesses have mentioned, in past decades that have moved to more truth in sentencing and strict determinate sentences. Michigan is one that moved there in the 90s. They saw a massive explosion in their prison population. That is actually significantly downward trended in the last 10 years as they got through the big lug of those sentences, and then changed their laws to get a bit more aggressive on parole. You have North Carolina and Texas that have done more of the transparency mixed with certainty approaches in recent years. You've had several states embrace the justice reinvestment approach, which is really almost entirely in focusing incarceration on violent and sex offenses, and really moving away from nonviolent and drug-related offenses. It's a very mixed bag. And then I would say very recently, and this is more anecdotal from just speaking to my peers, you're seeing more states bringing back strict sentencing for complete determinate, 100% of sentence served type of legislation. And that's extremely recent, and it's only been in some states, and we don't really know what the impacts obviously are, if those are passing yet or not.
Got you. And what would you say your biggest concern in if this legislation, these bills moved forward?
Probably the resourcing issue. It's hard to have just one. My resourcing issue, which again is addressable, but it is a significant issue. The impact of parole and being able to balance the presence of parole operationally, and then public safety upon release, and then likely just really using a sentencing structure to treat all individuals the same when they enter the system, and then not allowing the local courts through the judge, the prosecutor, the defense process to find a criminal sentence that best suits the circumstances of that case.
Gotcha. Thank you.
No further questions. So thank you for your time. Thank you for coming today and testifying. Any other informational purposes? Seeing none, Senator, some closing remarks on these three bills. Seeing none, that concludes the hearings on those Senate bills. Having no further business to bring before the committee, I now move that we adjourn. Do we have a second? All those in favor say aye. Aye. All those opposed say no. We are adjourned. I'll be able to get that.